The 1988 Malaysian constitutional crisis was a series of events that began with United Malays National Organization's UMNO leadership elections in 1987. The crisis finally ended with the suspensions and the removal of Tun Saleh Abbas, the long president of the Supreme Court.
United Malays National Organization UMNO has always been the leader of the governing coalition, Barisan Nasional. In 1987, UMNO held a leadership election. Tan Sri Tunku Razaleigh Hamzah stood against the incumbent President and Prime Minister Tun Dr. Mahathir bin Mohamad. Tunku Razaleigh was expected to win the election. The result was Mahathir received 761 votes and Tunku Razaleigh received 718 votes out of 1,479 voters. Tunku Razaleigh lost by 43 votes. Tunku Razaleigh supporters argued that the election has been rigged, and 12 UMNO members filed a suit in the High Court and asked for a new election. They alleged and showed the proof that 78 of 1,479 delegates were illegal delegates, and they were from unregistered branches. The plaintiffs also claimed that the election paper had been tampered. On 30 September 1987, the High Court gave the parties 2 weeks to reach a negotiated settlement. A unity panel was formed to handle the negotiation. However, the differences were intractable, where Razaleigh's supporters wanted a new election, while Mahathir's supporters insisted that the elections stand and that Razaleigh's king accept a compromise fair-saving solution. On 19 October 1987, the plaintiffs announced the continuation of the suit.
Mahathir, who had never been fond of judiciary, began making heated statements at this time. Mahathir also lambasted Black Sheep, who wants to be fiercely independent, to the public opinion. Soon after, 9 judges of the High Court were assigned to different divisions. Justice Harun Hashim, who was presided over the UMNO case, was then transferred from appellate and special power cases to the commercial crimes. However, because the UMNO case was already in progress, his transfer did not take effect until the case was closed. Harun later ruled that under the evidence presented, it was clear that several UMNO delegates had come from unregistered branches of the party. In line with the law, he declared he was forced to declare UMNO an illegal society, thereby dismissed the case of the plaintiff. Mahathir soon formed a new party, UMNO Baru, New UMNO, and within a year, the Safi Baru dropped, making it just a plain UMNO. Mahathir was upset if the judiciary increased independent, and in 1988, the government tabled a bill in Parliament to amend the Article 121 and 145 of the Constitution. This amendment divested the courts of the judicial powers of the Federation, giving them only such power as Parliament might grant them. The Attorney General was also empowered to determine the venues in which cases would be heard. At this point, Saleh, who is Lord President of the Supreme Court, began making strong statements about defending the autonomy of judiciary.
Tun Saleh Abbas convened a meeting of all 20 federal judges in the national capital of Kuala Lumpur. Instead of directly challenging Datuk Seri Dr. Mahathir, he decided to address a confidential letter to the Yang di-Pertuan Agong and the rulers of the various states. The letter stated, "All of us are disappointed with the various comments and accusations made by the Honourable Prime Minister against the judiciary, not only outside but within the Parliament." However, rather than calling for any direct action to be taken, the letter only stated the judges hope that all those unfounded accusations will be stopped. The King Sultan Mahmud Iskandar of Johor back in 1973, when he was still the heir apparent to the Johor throne, had been prosecuted for criminal charges by Tun Saleh Abbas as the public prosecutor. Tunku Mahmud was then convicted and eventually sentenced to 6 months imprisonment. It is not known that what the king did upon receival of the letter, but it seems that he informed Prime Minister that they agreed to take disciplinary action against Tun Saleh Abbas. Tun Saleh Abbas, who had gone overseas soon after the letter was sent, was summoned by Datuk Seri Dr. Mahathir upon his return. Tun Saleh Abbas later claimed that Datuk Seri Dr. Mahathir accused him of bias in the UMNO case at the meeting and demanded resignation. Then, Tun Saleh Abbas was immediately suspended from his post as Lord President. Although Tun Saleh Abbas initially agreed, but when he was later informed that his suspension was to be backdated so as to nullify some of his earlier actions in then-pending cases, such as UMNO case, he withdrew his resignation.
Then the government initiated impeachment proceedings against Saleh. Saleh claimed that the government attempted to bring him to resign. It was argued that the tribunal was improperly constituted because 2 of the judges were relatively junior, and that the 2 foreign judges were from countries that were noted for judicial independence. Saleh demanded to be tried on case of equal and make his hearings public. However, all of these claims were rejected by the tribunal. Instead, Saleh asked the Supreme Court to stay the proceeding because the tribunal's alleged improper constitution and the king had been wrongfully advised. The Supreme Court, in an emergency session, unanimously ruled that the proceedings stay. 4 days later, Yang di-Pertuan Agong suspended the 5 Supreme Court judges who had issued the order, on Mahathir's advice. This reduced the number of judges on the Supreme Court to 4. The tribunal eventually found Saleh guilty, and he was officially relieved of his position. Of the 5 judges who had supported him, 2 were convicted and the other 3 were acquitted. Soon after his dismissal in 1988, Saleh was conferred the Darjah Kerabat Yang Amat Dihormati, the highest honor that the Sultan of Kelantan could offer. Saleh contested the 1998 general election for the Lempah Pantai Parliamentary constituency under the Parti Melayu Semangat ticket, but failed to be elected. In the 1999 general election, Saleh was elected as Terengganu State Assemblyman for the constituency of Chetek on the ticket of Pan-Malaysia Islamic Party, which managed to form the new state government and had Saleh appointed as a Terengganu State Executive Councillor. However, he did not run the 2004 general election due to the poor health.
Based on the recommendation of the tribunal, we are on the opinion to say that Tun Saleh has been proved to have behaved himself in such a way as would destroy the public confidence in his impartiality, his honesty, his integrity, and in his ability to make decisions as a judge, and unanimously recommended that he be removed from office, both as a judge and as the Lord President of the Supreme Court of Malaysia, which the recommendation was accepted by the King. It must be remembered that to this day, no one knows what the result would have been if the Tun Saleh Arbas had appeared before the tribunal and been subjected to cross-examination. Tun Saleh did not do this as he said he did not recognize the tribunal in his interview. Even if one does not recognize a tribunal, one should appear before it and make the necessary submission, and if the submission fails, one should still give evidence setting out the defense. His version, even if disbelieved by the tribunal, will always be there in the record for everyone to see. In fact, the tribunal has stated categorically that if it had the benefit of a plausible explanation from Tun Saleh in regard to the several issues which were presented to it for its considerations, its decision may well have been different. By refusing to appear and give his version, especially in regard to his advocating the acceptance of the Islamic legal system in the interpretations of the laws as propounded by the muftis, he in fact had shot himself in the foot. It is no use crying fool when he did not exercise his right to be heard. What would he have done in similar or other cases presided by him? To our mind, it is still open to Tun Saleh, for instance, among other avenues, to ask for an appointment of another tribunal to review his case. Whether there will be any objection to this from any quarters, we do not know. Subject, however, to his agreeing to give evidence as to his defense. The record of proceedings are still there. Even if this happened, he will be running into difficulties because the four witnesses who give evidence at the tribunal were never cross-examined by his counsel. Tun Saleh, however, showed utter disrespect to the Agong who convened the tribunal by refusing to appear before the said tribunal to answer the charges. If an ordinary citizen is charged with any offences and is required by law to appear before a court of law, how can the highest judicial official of the country refuse to appear before a tribunal convened at the behest of the Agong? Thus, as no one is above the law, even the Malay rulers, as under the constitution they are required to attend before a special court should they commit any offences, how can Tun Saleh bluntly justify his actions in not appearing before the tribunal to defend himself, even if it is to complain that the tribunal was not properly constituted? Therefore, it was clear that Tun Saleh and his legal advisors, comprising very senior lawyers, did a disservice to the rule of law by their arrogance.
It's amazing that the argument continues after more than 2 decades. When an accused has exhausted all of his civil rights and is found to be guilty, the issue of his guilt is considered settled. The convicted party must complete his or her sentence and then proceed. However, in the case of Tun Saleh Abbas, the question of his guilt continues to be made. The lawyer attributed it to the government's inability to properly justify to the public the reasons for the establishment of a tribunal to examine the judicial corruption of Tun Saleh, the former Lord President of Malaysia's then Supreme Court. Until now, the key figures in the events that led up to the former Lord President's dismissal have been unable to properly justify or rebut the allegations leveled against them. The lawyer refers to Tan Sri Abu Talib, the former Attorney General who filed the charges against Tun Saleh in response to a complaint from the Agong, Tun Hamid Omar, the former Lord President who replaced Tun Saleh and ruled over the tribunal, and finally Tun Dr. Mahathir Mohamad, the former Prime Minister. They owe it to themselves to mount a vigorous defense against all of the falsehood and insinuations leveled against them over the years. Without fear of inconsistency, judges are held in the highest regard in the majority of democratic countries and often serve as the crowning achievement of esteemed practitioners who have mastered the craft skills. They must be a sound moral character, knowledgeable about the law, and possess unmatched honesty. Given the judiciary's standing in Malaysia and the seniority of the judges present at that meeting, it would not be irrational for lawyers to empathize with the judges' plight and naturally rally to their cause. Thus, when the judges leveled that accusation against the executive and the executive made no significant or successful attempt to justify that, while reserving the right to criticize, there was no intention to compromise the judiciary's independence. Lawyers were led to believe that the dispute extended beyond mere criticisms of incorrect decisions. This inference may be erroneous or wrong, however, this was the view of a sizable number of attorneys.
All in all, the removal of Tun Saleh Abbas is considered as legally appropriate.
However, the dismissal of the Lord President Tun Saleh Abbas during the 1988 judicial crisis was a national tragedy that haunts the judiciary to these days. Perhaps Malaysian judiciary will fully recover in the future, and we can safeguard judicial independence as no democracy can flourish.